It's really a pleasure to be here at the founding conference of Individual Sovereign University. If we're going to change the world, we're going to change the world one by one from the ground up. It's not going to happen from the top down. It's not going to be the case that we find some authoritarian leader who's going to very conveniently turn things into an optimal social state by snapping his or her fingers, right? Not going to work that way. The reality is that it's up to us, because I think it is always a risk when your model for success depends even briefly on giving the state more power. That's the leader model, and that's not the model of the sovereign individual. If we accept that individuals are sovereign, if we accept that power flows from the ground up, not ever from the top down, then I think we'll have a much more positive and fulfilling conception of what an attractive social order might be. We run into real problems if, even momentarily, we start to talk about power flowing from the top down, even briefly. So what I'm interested in here is thinking just a little bit about the nature of law in a stateless society. And I should begin by emphasizing that from my point of view, the state is problematic first and foremost because it is non-consensual, right? The official ideology of the state in our society is one in which the state rests on the consent of the governed. We use that language all the time, but everybody within the sound of my voice knows that the state does not enjoy the consent of the governed. Everybody within the sound of my voice knows that the state is in fact a parasite that is operating without the claimed basis in consent that it supposedly asserts. But the underlying idea that law ought to rest on consent is, I think, a very appropriate one. And the powerful thing, it seems to me, about anarchist conceptions of law is that, unlike any state-ridden environment we can imagine, in a stateless society, it really is the case that the law is something that is, for most people, grounded in consent. And so I want to talk about how that works and what we might think with regard to the exceptional cases. So for most people, law in a stateless society is indeed grounded in consent. And one thing that means, and I think we have to get this out of the way at the beginning, one thing that means is that the legal system in a stateless society can't be expected to be uniform. Okay, so the persistent idea, I think, on the part of some libertarian anarchists is that somehow in a stateless society we could expect to have a uniform legal code. And so while we might have competing law enforcement agencies and competing arbitration agencies, somehow we could have it be the case that these arbitration agencies and law enforcement agencies all presupposed exactly the same body of law. But I think realistically what you have to expect instead is a wide variety of sources and providers of law, both. So not just different people involved in offering legal services, but also, and at the same time, different people involved in identifying appropriate legal norms. And I think you can imagine a range of these. I mean, some of them might be geographically based. Maybe there are some persistent norms, for instance, in some areas about how water is handled. As we know, this is one of those things that varies from setting to setting. Similarly, I think even for those of us who are fairly skeptical about the legal institutions created by organized religions, we have to understand that almost certainly in a stateless society, religious legal systems would recover a lot of the vitality that they had in earlier years. Jewish law, which obviously has developed in a remarkable way over, depending on how you look at it, 2,500 years easily, plus another 1,000 or more before that. Jewish law continues to be designed in many ways precisely for people living in pockets of community life that aren't necessarily all collected together in one, geographically contiguous area. Diaspora Judaism, in fact, has always seemed to be one of the really powerful models for stateless law. You have these Jewish communities that aren't occupying coherent spaces that nonetheless are able to draw on legal traditions to resolve their disputes. I'm sure you'd see a resurgence of the Jewish legal tradition. Catholic canon law is enormously complex and developed, and I'm sure would continue to thrive in a setting of this kind. Now, it doesn't mean, obviously, that I buy all of the contents of Catholic canon law or of rabbinic law in its various forms. I'm just observing that some people would expect their disputes to be resolved per rabbinical law. And I'm sure there would be various cultural traditions and philosophical traditions and so forth, all of which would provide people with mechanisms for dispute resolution. Now, I think the key thing is that people can shift in and out of these, and so to the extent that they, in fact, do live within the terms created by this legal system or that legal system, they do so consensually. And in addition, obviously, to the culturally based models, there's surely going to be just arbitration services, dispute resolution services, which offer the opportunity to participate in the systems of law that they develop. Now, I think it's reasonable to expect that two kinds of things will happen with respect to these consensually based legal systems. So first of all, I think we can expect that people don't like violence very much. They may well be morally opposed to escalating violent conflict, but even if they're not, even if they are amoral bastards, they still are going to have every reason to avoid violent conflict whenever they can. Violent conflict is costly. Violent conflict is destructive. You don't get a good reputation when you're involved in it. So people aren't going to want to settle disputes by violence. What are they going to do instead? They're going to recognize that while there may be disputes that cross the boundaries of legal systems, nonetheless, those disputes are going to be resolvable in the same way that disputes which cross legal systems are today. As I'm sure everybody here knows, there is no super court in the international arena that resolves all problems between states or between people who live under the authoritarian rule of different states. The fact is, there's a whole set of complex choice of law rules, conflict of law rules that play out in disputes that occur between geographically localized legal systems, and that I think clearly could do the same thing with respect to not necessarily geographic legal systems of the kind that we're envisioning here. So, I think it is surely going to be the case that people will work out mechanisms for resolving disputes between legal systems, across legal systems, because that's what the market wants. The market clearly is going to want to minimize conflict and to make it easy for people to know that they can count on ways of resolving disputes, whether they're involved in commercial or other transactions with people who adhere to the same legal principles they do or not. So that's point one. There will be conflict resolution mechanisms of all kinds. Point two, I think we can reasonably count on, is that that will lead to a measure of convergence, right? It is going to be less costly for different legal regimes to resolve conflicts if the conflicts are less likely to arise in the first place. And how are they less likely to arise? If standards are agreed on. So let's take a potentially contentious issue. So let's say, for instance, at any rate, you have a bunch of legal systems which adhere, and I don't mean for a moment to suppose that this would be true for all legal systems, but let's just suppose for a moment you've got a bunch of legal systems which disagree about various other things, but which operate with a broadly Lockean conception of property rules, okay?